So there's been, I think, three main trends this year, among other interesting things that have happened. I think the first one is probably the parental liability development, and we have seen the Goldman Sachs case in which a financial investor was considered to have exercised decisive influence and hence was held liable as a parent company for the involvement of its subsidiary in a cartel. That is an interesting development, and it follows from the AXO 2 case that was adopted last year, in which we saw the Commission imposing a fine on a parent company despite its subsidiary having been prescribed and found not to have to pay any fines in infringement. The second development, I think, it's a very important one in relation to settlement, on which I'm going to be speaking in the conference in a moment. It's an interesting development because it is a key finding of the court in that case was that the way the Commission has been exercising its power to do settlement cases is actually being found to perhaps, because the case didn't really actually get a clear decision on it, but that it could be that the way the Commission has been doing cartel settlement cases in a staggered way could actually be breaching the presumption of innocence and be breaching the rights of defense of the parties, in that there may have been some kind of prejudging of the decision on the ordinary contested procedure for non-settling parties, whereas the Commission had already adopted a number of months and some time over a year before a decision finding that in the same cartel a number of companies settling were found to be guilty on that. I think the third development has been in relation to damages actions, and so we have seen a number of actions proliferating in relation to, for example, the Trax cases, and so there's a number of those pending across different jurisdictions, notably in the UK. And in that jurisdiction we have seen very recently, just a couple of weeks ago, the first adoption by a UK court of a granting of damages for a company on a follow-on case. So that was an interesting development as well. So on the parental liability front, I think we will keep a close eye to cases as Pirelli and others in which the same issue at stake than the Goldman Sachs case is being assessed. So just to see the treatment of financial investors and whether the Commission still considers that in certain occasions they can be found to have been liable for the behavior of their subsidiaries, even if they are financial investors. On ICAP, very, very important developments coming up this year. We have three cases at the court, in the steel abrasives case, Pometon, and then in the Trax cases, the appeal by Scania, and in the Euro cases, the appeals by HSBC, JPM, and Credit Agricole. All those cases have similar arguments to ICAP, and what the Commission, what the courts already found in the ICAP judgment in relation to whether the Commission is going to be doing staggered cases for settlement in hybrid cases, or will they do parallel proceedings in which both the settlement decision and the contested decision are adopted on the same date. An important thing on this, and a development we will certainly see, is whether the Commission, who is appealing the ICAP judgment but has not decided to put that point as a plea, is actually taking the advice of the court and decided to do both settlement and non-settlement cases at the same date. And an important point of this as well, a consequence of this is as well, how would companies that are faced with the choice of going in for settlement, how will they react to the fact that the proceedings now for settlement, if the Commission abandons the staggered approach, that will mean that the settlement cases will also be spun out over a longer time period. So that also impacts on the incentives of companies considering accepting settlement proceedings. In relation to damages actions, what we can expect in 2019 2019 is actually more actions for damages being lodged probably against the Commission decisions, and importantly the Commission will also need to decide whether it brings forward the legislation it is considering in relation to collective redress, which is something to keep an eye on. I think we have seen a drop in cartel investigations over the past year. I think the statistics were around 1/3 of the cases we were seeing 4 or 5 years ago. So it is a fact that there's less cartel investigations now. There's been various theories around why this could be, and I think a plausible explanation it is that companies are actually pausing and taking a moment to consider whether, when they find out that there was some conduct that breached potentially competition law, whether they run to the Commission and they come forward for immunity. And the reason for that is probably based on the Damages Directive and how successful that Damages Directive is being to date, and the sort of exposure to the cartelists that are facing an ever larger amount of fines, not only from the administrative proceedings before the Commission, but also from the civil actions, factors in as to whether yes or no to give that step to go for leniency. Interestingly, some other jurisdictions, so national competition authorities in Germany and France, they haven't seen any drop in the cartel cases, and that actually leniency applications are still rising. So it is not, I don't think we have an homogeneous answer in Europe, but it is certainly something to consider. In terms of cartels, I mean, she has given some big ticket cases, Commission decisions. So, for example, the Trax case, in which she imposed a very large amount on several track companies. But I think what will be remembered from her mandate is more big cases against US and multinational companies in relation to abuse of dominance, more than cartel cases. On cartel cases, I do think, however, it is a fact as well that a very big number of settlement cases have been decided by the Commission under her mandate. So she has, in that respect, been quite focused on pushing on the settlement notice. And I think finally what may be interesting is that we may be seeing under her mandate, she may be actually opening the first cartel investigations around more sophisticated cartel tools as the algorithms or artificial intelligence. Some national competition authorities have been quite active on that, and we may see under her mandate some investigations on that as well. My main takeaway from this conference is that it is by far one of the biggest ones in terms of the choice that it offers on competition matters, but also the depth of the panels. It is quite practical, the approach that panelists use. It has been going on for a number of years, and I think you just have to look at how big it is and how interested everybody is in coming for identifying the reasons for its success.